Denims has officially won her fair use battle, and we're also going to get into the cases involving Casey Tronfrogen, etc. As a total recap here of really the Hassan Piker content nuke fair use case, yes, Ethan Klein can appeal, but the chances, being realistic and being just totally neutral here, are not good for an appeal. So what happened? Let's get some background here on this case. So this is something that, hey, I wanted it to go the other way. I was saying, hey, look, I think it's bad precedent. I think it's bad law. I think this is going to be a bad way to structure it. But with any fair use case, and this is very, very true of all fair use cases, you really don't know which way it's going to come out because the judges can rule differently and different judges can weigh different factors differently, or two different judges can look at the same set of factors and say, hey, this one has weight here or this one doesn't. So this is a case that really I was very fervent on. But you know what? Sometimes in the law, you don't get your way. Sometimes you want it to be a certain way, and it doesn't turn out that way, and you just have to accept it. And that's part of one of the things I love about the law. And, you know, yes, well, was I a little hyperbolic in the past about it? Sure. About, my position, right? My position that she should not, or at least it should have gone to discovery, which we'll get to a little bit later. So clearly, once again, being unambiguous, Denims did actually win. And the way she did that was fighting back with a motion for a judgment on the pleadings, which was a pre-discovery early stage motion. And when they looked at the factors, which was really interesting, so they found the purpose and character was actually transformative, which is very, of course, important for fair use. It's got to be transformative for it to be fair use. But then you've got amount and substantiality was reasonable in context for commentary, and it really sets the bar for kind of reaction content. So, looking at Denims, you're able to say, okay, this is where, you can have reaction style content, and as long as you're doing as much as Denims did and you're, having as much as she said, that's enough, right? So that judge looked at that and said that amount is enough. So now that's the bar. So this is where, I think a lot of us had also a contention. Obviously, there's the point about the market substitution, which the judge did not agree with. But with this is about the amount of time. So this is saying that looking at Denims' video, you can look at that video and say, okay, she sat in her chair, she got up, she did other stuff. So at some point here, that is enough for reaction content. So there you go. You've got that there. The judge also found there's no substitution and it was a different viewing experience. It was not a market replacement for the original. So there you go. So saying, hey, look, that is something that was okay. Now, this is something that was hotly debated. And I think this one, with the market substitution, saying that this is, for example, this is something that is going to be viewed by people who are, hate watching, etc. Or, they're going to not want to watch the original content. So they're going to go over here and watch that. But the judge said, hey, look, that's not substitution. It's a different viewing experience. And you've got to say, okay, well, that's the way the judge wants to set it. Even if someone comes out like Denims and says, hey, yeah, no, I'm doing this just so you don't watch it on their channel. Well, there's a certain level of that is acceptable. Now, that's not to say, because fair use depends on the judge, that every judge would rule that way. Different judges could rule differently. And that's the beauty, once again, of fair use, is that different judges can rule differently when things are weighed in the fair use balancing. Over here, we've got an opinion of a copyright specialist, because, I'm not a copyright specialist. I once again, I cover all topics, right? And look at all topics. But if you look at copyright specialists, people that actually know what they were talking about, even they were thinking this was going to get further than it did. So even they were shocked. Even the copyright specialists, the people that focus on this, Aaron Moss, who's a partner at Mitchell Silverberg MSK in Los Angeles. And he wrote an article here. He says over here, in my coverage of Denims' motion for a judgment on the pleadings last month, I predicted Judge Wesley would deny her early fair use bid and send the case to discovery. Instead, his draft ruling ruled ahead of last Friday's hearing on the motion, found that the stream fair use as a matter of law. So found the stream fair use as a matter of law. So boom, there you go, fair use. 3 of the 4 fair use factors broke for the defense. and they heard 40 minutes of attorney argument and then took the matter under submission. And while Denims' corner of the internet is already measuring her crown, no final order. Now, this is actually an older article, so the final order has been issued. So this is something that has been updated. The one thing, once again, I want to point out is that even they thought, hey, this would go to discovery. So very reasonable people that have copyright experience were shocked on this, that it was ended this early. And that's something I was surprised on as well. I mean, I thought this would go a little bit further. We might see more of this case, but this case ended a lot earlier than predicted, much earlier than predicted. I want to also summarize what's going on with the other ones, because I think this is really important. And looking back, now that we have a closure, right? Now that we're done with the whole Klein saga in terms of Casey Tron-Frogan and Denims, we can kind of analyze all of them. Now, Denims, clear winner here. And once again, props to Denims. I can disagree with her. She can make fun of me, which I deserve. And listen, sometimes I deserve it. And, she wants to make fun of me. I get it. Denims, definitely the winner. 100% the winner, because she went through, she actually did the work, and she put in the time, and she had a good argument, and that argument was persuasive. But Casey Tron, also very smart. And Casey Tron settling with Klein with an apology, citing family reasons, not wanting to get into a protracted battle. Also very smart there, just doing an apology. Looking at all of this, I think that was one of the easier ways to get out of this too, is to say, hey, let's just settle, let's have an apology, and let's just, clean things up here. Frogan had that clerk default on May 20th, 2026 over a failure to file a response to the complaint. And with that, once again, there's a default there, but there's still damages that need to be determined, and those damages can potentially be high. Now, the judge could say the damages are lower. We don't know yet. We got to go to that damages hearing that's scheduled for August 10th, 2026. So we've still got something for Frogan, but that's just as to damages. That's just as to how much are they going to rule in that particular case. And of course, she had that legal defense fund money. We don't know what happened with that legal defense fund money. So that's what's going to happen right there. So in my judgment here, Denims' lawyers made a very successful argument. She gets her win. She gets her day in the sun. She gets to take her moment. The real lesson that people should learn from this, and this is very important, is that fair use cases always have a high amount of unpredictability and can vary from judge to judge. So it's impossible. Even specialists, even people who know a lot about fair use, who really focus on it, that's the thing they do, cannot call things precisely, right? It's not possible to do that. We make our best argument. We look at what might be good precedent or bad precedent in the future, just thinking about things holistically. But in this case, this came out in Denims' favor. Wasn't necessarily predicted by everybody. Some people were, once again, Denims, obviously she wanted this to come out that way for obvious reasons, right? Everyone wants to win their own case. But I do believe, yes, it may be a bad precedent, right? I can disagree with that precedent, but I respect that judge's ruling. So I get it. That makes sense. And I can respect that judge's ruling and kind of take that and apply that to future cases. So it's kind of a learning lesson for future cases involving fair use and how to analyze them. So that's my take on this, guys. I mean, once again, I am just accepting the egg on the little bit of egg on the face from me being a little bit hyperbolic. Sometimes, hey, it's the internet, things happen. Now, once again, it doesn't mean that every case is going to come out like Denims, but it does set some standards. I want to know what you guys think about these cases. Let me know in the comments below, and I will catch you on the next one.